Welcome everyone to New Exposures, More Risk, Navigating the Employment Practices Liability Landscape. Thank you all so much for joining us. Please send questions through the Q&A today. We will try our best to answer all of your questions, but if for whatever reason we are unable to get to your question today, please email learning@nfp.com. Today's presentation is being recorded and the recording will be distributed in the coming days. At this time, I'd like to hand over the call to Matt Schott, Managing Director of Management, Cyber, and Professional Liability at NFP. Matt, the floor is yours.
Thank you, Amber, and thank you everyone for joining our New Exposures, More Risk, Navigating the Employment Practices Liability Landscape webinar. This webinar is part of the NFP Management, Cyber, and Professional Thought Leadership Series to help inform and educate our clients. We are very excited today that we have our experts from both NFP and Jackson Lewis to cover a myriad of topics that we think clients should be thinking about. In today's evolving landscape, employment practices liability insurance has more potential exposure than ever before, including but not limited to the things we're going to discuss: remote work, compensation issues, and privacy. Similar to cyber insurance, you're going to hear a lot about preventative measures that will go a long way in mitigating your employment practices risk and exposures. Working with specialists on the insurance broking and legal side like NFP and Jackson Lewis to review your policies and procedures can only help you get out in front of these issues that this panel will be discussing today. Now, without further ado, allow me to introduce this illustrious panel. From NFP, we have Maura Marone and Jonathan Franznik, senior leaders within the management, cyber, and professional liability claims advocacy practice. And from Jackson Lewis, we have Michael Santaki, who is special counsel risk management, and Joe DePalma, equity principal and a Jackson Lewis labor and employment expert. I will now turn the webinar over to Jonathan Franznik.
Thanks, Matt. And thank you all for joining us today. Maura and I are happy to be working with our friends at Jackson Lewis to let you know what we're going to watch out for in the employment practices arena in 2024. As Amber mentioned, if you have any questions, please submit them through the Q&A function, and we're going to work to get to them. And if we have any time at the end, we'll answer any of those questions as well. As Matt referenced, we're going to be talking about a number of issues, including artificial intelligence, or AI, diversity, equity, and inclusion, also known as DEI, remote work, cannabis in the workplace, pay transparency, the Pregnant Workers Fairness Act, and we'll wrap up with the latest trends in employment litigation and what the EEOC is up to. So given that we have a very packed agenda, I'm going to dive right in, and we're going to hand this over to my colleague, Maura Marone.
Thanks, John. So like John said, we have a packed agenda, so let's jump right in, starting with AI. So Jill, this question is for you. Artificial intelligence has evolved rapidly, and when I think back to movies like The Terminator or I, Robot, the concept of robots adapting human qualities seemed far-fetched, right? But now AI has advanced to where it can understand and generate human-like responses. And its evolution has outpaced governments and regulatory agencies and their efforts to manage the AI space. However, within the last year, we've seen those agencies take proactive steps in managing AI with the EEOC's technical guidance and then President Biden's executive order. Can you talk to us a little bit about the current efforts to regulate these AI?
Yeah, sure thing. So you're right. AI is moving fast. Government moves slow, as you know. There's been some legislation regarding AI that's been introduced, but there's currently no existing federal legislation specifically governing its use in the employment context. There have been some important rulings, which we'll talk about today, and some states and localities have implemented some laws and regulations. I'll give you some examples. So in New York City, employers in New York City using AI, data analytics, or statistical modeling in their hiring and promotion process will need to notify candidates in advance and conduct annual bias audits. This is a law that went into effect on January 1st, 2023, and failure to comply with it results in fines of $500 for first-time violations, $1,500 for subsequent violations. The law is very broad and applies to any automated employment decision tools, which is defined as any computational process derived from machine learning, statistical modeling, data analytics, or artificial intelligence. So it's a very broad law that's requiring employers to give notice and be mindful in using it. The EEOC, the Equal Employment Opportunity Commission, they launched an initiative back in 2021 to study AI tools used in hiring decisions, and they highlighted the concern over bias and discrimination Illinois passed its own AI employment law, which gives job applicants the right to know if AI is being used in a video interview and the option to have the video data deleted. Maryland passed a law requiring job applicant consent for the use of facial recognition technology. Washington, D.C. has proposed legislation that would regulate algorithmic decision-making, and that requires an annual audit similar to those in New York City. So there's a lot going on, a lot to pay attention to, a lot of different areas this is covering.
Thank you. So you mentioned issues like potential bias, et cetera. What are some of the other potential concerns that employers should be aware of? And have you seen an increase in AI litigation in the EPL space?
Yeah, for sure. So with the more legal action settlements that are on the way, employers will need a strategy for the proper use of the AI tools. You have to be mindful of Title VII of the Civil Rights Act, which, for those of you who don't know, it's the law that prohibits employment discrimination based upon race, color, religion, sex, national origin. So in May of 2023, the EEOC issued a technical assistance document governing AI and Title VII's application. The guidance urges employers to be mindful of potential bias and discrimination in their automated systems and to regularly evaluate and monitor these systems to ensure compliance with Title VII. You also have to be careful of risks with the Americans with Disabilities Act. I might call it the ADA. Again, that's a law that prohibits discrimination against individuals with disabilities in various areas, particularly employment. So when you think about AI and the ADA and its implications, the considerations that come to my mind pertain to employing persons with disabilities while using AI. So the first instance is these tools need to be accessible to persons with disabilities. So to the extent that you require employees to use any AI type tools, those tools would need to be accessible to persons with disabilities. The other thing to look at, the EEOC also issued technical guidance as it relates to the ADA and employment. And there, the guidance explains that the employer's use of an algorithmic decision-making tool may be unlawful for a few different reasons. One, the employer does not provide a reasonable accommodation necessary for a job applicant or the employee to be rated fairly and accurately by the algorithm. So these are the situations where we're seeing them where employers are relying on their computer systems to make certain decisions. Employment decisions that were formerly made by humans are now being made by machines. And these machines aren't perfect, and they don't consider every single aspect of the laws that they're required to. So we encourage employers to consult with their counsel, to consult with their HR folks, to be thoughtful for implementing a decision that's suggested by an AI model.
Thanks. Does someone want to jump in? All right, so Mike, this one's for you. From a risk management point of view, how do you counsel your clients in avoiding or mitigating their AI risk?
So, my clients are the internal folks at the law firm. AI, I look at AI less from an EPL perspective, employment perspective, and really more so from all the risks inherent to using AI. So first, I think as a risk manager, I have to look at whether something is prevalent in the type of industry that I'm working in. And a law firm, certainly AI is a big challenge, right? I think the biggest issue with AI is that fear that I have that, it's 4:30, someone has to work on something, it's due at 5, they haven't started it yet, lawyers are busy, and they go to AI and they kind of, I don't want to use the word cheat, but they take the short path that AI gives you, and now you have, a malpractice problem down the road. So I think, for me, that's my biggest AI worry, less of an employment one and really more of a problem with work and in a professional capacity.
Thanks. So I guess, and John, you can chime in here. When you think about the NPL policies like EPL, DNO, et cetera, I think what we're seeing now in terms of the the EPL coverage is that they're basically the run-of-the-mill claims. So it's the discrimination, maybe the wrongful termination. And there was that iTutor case that the EEOC settled. I think it was sometime last year. But John, can you speak to the DNO and the ENO aspect of it?
Sure. Thanks, Maura. And yeah, to piggyback on what Michael mentioned, there was an infamous case where an attorney used ChatGPT to come up with a brief. And again, tools are only as good as your monitoring of them. I think it fabricated some case law it was relying on. So in that situation, the court, was able to smoke that out, and that attorney was in trouble. Certainly, E&O policies, lawyers' professional liability policies, would be responsive to such claims. To the extent that there's a bigger issue with the use of AI that affects a company's bottom line, negatively and significant enough, where there's a significant stock drop, shareholders may bring suit, or there might be some regulatory investigations to which D&O policies may respond. So AI does present a risk across many lines, and including all types of businesses and industries as well. It's not just the employers who are looking for candidates. It also could be an issue with not-for-profit entities, including colleges and universities who are using AI in their admissions process, might wind up with a disparate impact claim, or also people who are applying for grants that, they're going to get a lot of submissions and they're using these AI filters to cull them and get to an ultimate resolution. You have to be careful in terms of what search terms you're using and how that is going to play into the ultimate decision that you make.
That's true. And I know with regards to the ChatGPT, there were issues where I think answering mathematical questions, it was completely, incorrect. So a lot of work, but more to go. As much as I would love to stay on the AI topic, we have to kind of move along to DEI challenges. So Joe, this is for you. DEI has been a really important issue over the last few years, and more so recently because we've seen various attacks and efforts to kind of do away with them. And racial tensions over the last few years have called for a kind of renewed D&I initiative, especially within large corporations. Have you seen an uptick in cases challenging the D&I initiatives?
Yeah, sure. So we have, there was that U.S. Supreme Court case involving Harvard University and admissions, and that's where the court held that the use of race in university and college admissions is unconstitutional. And since then, we've been seeing an uptick in DEI initiatives and potential challenges. So when you think about that ruling and you think what it was only addressed at admissions decisions of an educational institution that accepted federal financial assistance. But we do see, and we are anticipating more claims where employers are going to make similar type of challenges in the employment context. And that's going to be looking at the DEI initiatives that employers are rolling out. And that would cover employers that aren't receiving federal financial assistance as well. So we see the legal roadmap there, giving employees a path to start challenging these DEI measures. And we're seeing some of it happening already. The specific uptick we've seen is in reverse discrimination claims. And that's where certain DEI measures are being used as evidence of discrimination against white or male applicants or those who are historically privileged. So when you think about it, companies are trying to promote DEI. Sometimes that means certain people who are historically privileged are being looked over in lieu of people who are historically underprivileged. So we're seeing a lot more of those claims coming across our desk at Jackson Lewis. And we anticipate that continuing for a while.
Thanks. So you mentioned the Harvard case, which was the affirmative action case with Asian students. There's a really important case that's pending before the Supreme Court now, Muldrow versus the city of St. Louis. Can you touch on that for us?
Yeah, so Muldrow, I'll give you a little bit of the facts. She was a sergeant, and she was initially assigned to the intelligence division of the FBI, where she worked on various high-profile cases and was deputized by the FBI. She was ultimately transferred to the 5th District by the interim police commissioner. So that was a transfer of her position. In the transfer, it led to her having a different work schedule. She had slightly different responsibilities. She lost the special FBI-related privileges, and it included a potential $17,500 annual overtime pay that she lost. So after her transfer, she was asked to return all of her FBI equipment, and she returned it, and her task force officer status was revoked. She then filed a discrimination charge with the Missouri Commission on Human Rights against the city of St. Louis, the captain that transferred her. And then she later filed an action in Missouri State Court alleging Title VII violations. The case was then removed from the state court, where it went to the federal court there in Missouri, and the federal court dismissed her claims. She then appealed it to the U.S. Court of Appeals for the Eighth Circuit, which affirmed that dismissal. And they held that the employment decision she alleged did not constitute an adverse employment action, and thus did not establish a prima facie case of gender discrimination under Title VII. And the actions weren't materially adverse, which was required for a prima facie case under Title VII for retaliation. So now the case is up in front of the Supreme Court. They heard oral argument on December 6, 2023, and we anticipate a decision in 2024. And that's important for us to pay attention to, because there the lower courts are basically writing into Title VII that the employee needed to prove materially adverse actions. It's clear that the transfer affected the terms and conditions of her employment. But the question is whether that's enough to rise to the level to be a violation of the law. So that decision should be insightful. Based upon the way oral arguments went, we anticipate that the court will find in favor of Muldrow, but we shall see.
Thanks. So Mike, tap it into your risk management expertise. How do you assess DE&I risk when you look at a company and try to determine whether they're low risk or high risk for potential DEI claims?
I mean, so first let me say, I think a lot of Jackson Lewis included, we have DEI. It's important to contracts that we seek, and we do a lot of RFPs with municipalities and state entities. So I don't know if you can say I don't need to, do DEI. I think a lot of entities do have to institute a DEI policy. I think the most important thing as risk manager is this sense of awareness. I mean, if you think about it, if you take this entire presentation and go back in time 3 years, nobody would even remotely know what we're talking about, right? Not that long ago. I mean, AI was, I think 2 years ago was the first time I heard the word AI, kind of similar with DEI. So I think for people who are in a similar position to me, the most important thing to do is to have an awareness of these things. They're moving at maybe a quicker pace than they used to. And you can't sit here and be unaware of it, or simply to willy-nilly institute a policy without sort of taking into account what some of the ramifications could be. So I think having an awareness of it is important. Knowing that in all likelihood, you do need to institute something, especially, again, if you have contracts that demand it. And then I think it's also just engaging experts. Nobody can do everything on their own. And if you start a DEI policy, I think it's important to consult with experts who know how to do it, who know how to navigate it. And those are just the important things to assess. I think ultimately it's so hard to assess a risk because so much involves the human element. That's a great unknown that it isn't easy to assess. But I think it's really important, if you can't assess it perfectly, to at least be aware and really have a full awareness of going on in the space. Take a look at the cases, get an understanding of where the suits are coming from. Another thing, when I say speak to experts, as clients of NFP, you've got, your broker's not just transacting insurance for you. I think they can either give you advice, put you in touch with experts, but this is certainly a time where using a good broker like NFP and having them, involved in some of the decision-making to help you is important.
Absolutely. We could actually talk about DEI for an hour, but unfortunately we have to kind of move on to our next topic, our next issue, and that's remote work. So Joe, this question is for you. Remote work has been at the forefront of employment-related discussions, especially post-COVID, when employers are trying to grapple with the challenges of remote employees. What are the top concerns that employers should be aware of?
Yeah, I mean, so there's a host of different issues that we've seen. I remember in early 2020, when Jackson Lewis, we decided we needed to make our entire 1,000 attorney law firm go remote, and we were not equipped to do that. There were a lot of different hurdles we had to get through, and it took a full team effort to make sure that we kind of attacked all these things, both from an employment and operational perspective. So just going through a list, you have data security issues, right? With employees working from home in different locations on different servers. You have so much different sensitive data that's being spread out across the country, more globally than that. It's easy for data breaches to occur. Similarly, cybersecurity, phishing attacks, malware. That's something that's very big that companies were facing. you have to comply with a whole host of employment laws. So if you were just operating in one state, say if you were in New York only, now you're remote and you have people working all over the place, New Jersey, Connecticut, anywhere close by, you have to be mindful of the employment laws in those states. You have to be mindful of their workers' comp coverage, their unemployment insurance, whether they have different paid family leaves. These remote employees are now employees of the state in which they're working from. So that's something that a lot of employers had to adjust to and be mindful of. You also had issues with employee well-being, people being burnt out, isolated, and focusing more on wellness was important when you have all of these people remote all over the place. Another huge challenge from the employment perspective is how do you measure employee productivity and performance? You don't see someone in the office every day. You're not sure if they're really putting in a 9 to 5. So now you have to be a little bit more thoughtful and intentional with what you expect from employees from an output perspective, from a communication perspective, a responsiveness perspective. Those were all things that we're seeing, coupled with how do you develop policies to make sure that you're addressing everything that you need to address for everywhere you are. So again, piggybacking off of what Mike said, you have great brokers who can put you in touch with experts. You have employment attorneys out there that can help and really develop a full comprehensive solution and approach to ensure that you're carefully considering everything you need to consider in the remote work environment.
Thanks. So Mike, Joe mentioned having policies and so forth that address these issues, remote work, et cetera. Is there any other advice that you would give to an employer in navigating some of these complexities?
Yeah, so I think one of the things Joe mentioned everything but one, but very important is the workers' compensation. And again, this is a segue to sort of say call your broker, but I don't mean to do that. But we had a case where somebody was part of a Los Angeles office, worked remote. He was in a state that we do not have an office in. And by the way, we're in most states, but there's a couple of northwestern states that we don't have an office in, and that's going to be a workers' comp violation if that individual is not set up. It is really important that there's connections between the HR folks who will be presumably handling some of these workers' comp issues and the ability of that person to work remote. The other thing that I'll touch on that Joe touched on is the data security issue and how safe these connections are with a remote connection to the office system. And also the consistency of practice. But one thing that I think is also important to mention is someone might be listening to this and they say, well, let me just end remote work right now because it sounds like there's problems with it. But it's become abundantly clear to me that for many entities, in order to attract talent, you do have to offer remote work. And if a company hung a shingle out there that said 5 days a week, 9 to 5, they will not attract the talent that will go elsewhere. So I think if you first establish the fact that remote work might be here to stay for a while, I think it's important to look at those two buckets. One would be the substantive issues like workers' comp and data security. And then the other thing is maybe more the nuanced, but it's a focus on consistent practices. Does one department have different mandates than another? I think those things are really important. But again, to me, and just from personal experience, that workers' comp thing is really important because it's out there.
So we have a couple questions that came in that I want to pose to the panel here. Someone asks, do we need to be mindful of other state laws if an employee is hybrid, but mostly in office?
I'll answer that one. The short answer is yes. You have to look to see where they're working majority of the time, where they report to. There's a difference whether they're working remotely for their convenience as opposed to you asking them to work remotely. So say hypothetically, you have a New York City office and someone who lives in New Jersey, they report to the office 3 days a week, but work from home 2 days a week. In a situation like that, we would argue that New York City law is the only law, New York State law is the only laws that would apply. That's different than a situation where you have a New York City office and the person lives down in Maryland and they come to the office periodically. Their home office will be considered Maryland. You'll be mindful of those laws. My advice is always to try to avoid New York laws, but those are just the examples I used.
Okay, and I think I have one more for you, Joe. Productivity checks done by remote monitoring. Is that legal? Is it, you know, are some people towing the line there, or how does that work by remote monitoring of employee productivity?
When we say remote monitoring, do you know what we mean?
I do not. That was just the question.
The short
I think by the, you know, big brother employer, we'll assume.
Yeah, so that's one of the situations where if you pick up the phone and called me and asked me that question, I would hook you up with our data privacy team. One of the things I will always say is that if you are going to be doing any sort of remote monitoring, it needs to be in a policy. You need to disclose to your employees that you're doing it, and you're monitoring the systems. Typically, in your handbook, you'll have some sort of electronic communications policy that your emails and your computer is the property of the company, and we have the right to monitor it, et cetera. So my short answer is yes, you can do things like that. You need to disclose it, but I would definitely want to loop you with an expert to make sure that exactly what you're doing is lawful and we're thinking of every consideration.
And by the way, if I may, Joe just touched on something. I was thinking this recently. We updated our handbook recently, and I think, you know, if Jackson Lewis with 1,000 lawyers is updating a handbook, there's got to be something on that horizon that says we should have done it. Something like this, where you would want to disclose whatever it is you're doing with remote work, that's probably not going to be in a handbook that's 5 years old. So, you know, as people listen to this discussion, a handbook that you may have may be very dated right now. And it is important to provide thorough updates in that employee handbook.
Hey, John, there's another question. How do you account for people who are nomads moving state to state? Try the Joe or Mike.
Yeah.
Yeah, so as an employer, and that's kind of a loaded question, I would ask a lot more questions as to how they're a nomad. Or they just independently moving from house to house and deciding where they want to live? As an employer, you have no legal obligation to employ someone in a jurisdiction that you don't want to be in business in. So the first thing I would want to do is address, why are they a nomad? If they're a nomad for the purpose of their work, in that they have assignments and that they vary from state to state, they'll be in one place for a month and another place for a month. In those situations, they would likely be subject to the laws in which the office they report, and then potentially the laws of the state where they're spending a meaningful amount of time. So, I mean, it's very fact specific, case by case type of inquiry there, which would require more information to really develop the plan of attack.
Well, thank you for that. So again, as much as we can talk about remote work for another 20 or 30 minutes, unfortunately, due to interest in time, we need to kind of move on. So moving on next to cannabis or marijuana. So Mike, this is to you. Marijuana laws have been extremely confusing for employers over the last few years, especially because there are a hodgepodge of laws across the states, but also because it's still illegal federally. So what guidance do you give clients in helping them with their drug testing or no tolerance policies?
So, I mean, I think testing is really difficult. And I'm not as familiar with the specifics of the law. Maybe Joe can chime in on that, but you, I think, really have to have a connection to some sort of physical labor that requires you to be, you know, absolutely without any influence. So I don't think many people can or do drug test. And I think the biggest issue with marijuana laws as they evolve, and yes, there's federal, there's state, but I think it's more of a sense of adopting a certain, avoiding the knee-jerk reaction and adopting a tolerance. I don't know if that's the right word, but maybe avoiding the knee-jerk, avoiding that sense that, you know, oh my God, I just saw this guy smoking on the corner, or, well, you can't really smoke and go to work, but you know, there are legal shops opening up across the street from our office. It's a challenging issue for employers, but my thought is, and I've seen a couple cases a few years ago, if I can give one sentence advice, it would be careful. I think the onus is on the employer to really show that what they're doing is absolutely necessary to the job. And what we once thought of as, I can't believe that guy's doing that, may now be, he's kind of okay to do that. So I think that you have to be really careful with this evolving cannabis laws. And I think California has some laws that are even more liberal minded. I would tread very carefully, and certainly for those that look at marijuana with a more traditional focus, you may want to have to change your look at it. I think ultimately, and this is more of a personal opinion, marijuana is just going to evolve to be on the same page as alcohol. So in other words, whatever your policy is for alcohol, essentially the same thing for marijuana, and that's just my own personal observation.
So Joe, what are some of the cans and cannot do's when it comes to employers in implementing these policies?
Yeah, I think the biggest thing I would counsel is don't be too quick to come to a discipline type decision when it involves marijuana. I think the slide says 39 states have legalized marijuana. A lot of states allow it for medical purposes. So you want to be thoughtful and mindful before you take an action that's going to be adverse to an employee on that basis. With drug testing, you could still do drug testing. In New York, where you can't test for marijuana, but in other places you can. But there are other drugs out there besides marijuana, so we still see drug testing policies. What you definitely should do, going back to the employee handbook, is you should have a comprehensive drug policy in your handbook that specifically sets forth what your expectations are. Something Mike said was that you can't smoke at work. Sure, we're not allowed. You're not permitted, or sorry, employees aren't permitted to come to work high if that goes against your policy. One of the bigger issues I see here is in the ADA context, or persons with disabilities who are prescribed medical marijuana, and they say, I need to use this for treatment of my health condition. Their employers have to take that seriously and go through an interactive process just as they would with any other request for accommodation, and can't just poo-poo it simply because it's marijuana. So I think when you say which are the do's and don'ts, just don't act too quickly in dismissing something that just doesn't sound right, and make sure you have a good policy in place that's vetted, and ensure that your management is trained on how to enforce and understand that policy.
Thanks. So in terms of the insurance aspect with EPL, we've seen claims with discrimination, like you mentioned, the ADA, harassment, perhaps retaliation. Are there any other kinds of claims that are being brought by the plaintiffs, or does that pretty much capture?
I mean, it's a lot of discrimination claims. There was a case out of Pennsylvania where it was brought by an employee who was terminated because they used medical marijuana. So the employer just didn't want to hire someone that used it for a medical purpose. They brought a suit. In New York, for example, employers are prohibited from discriminating against employees based on the employee's use of cannabis outside of the workplace, outside of work hours, and without the use of employer's equipment. So someone who likes to go home every night and smoke in New York, we've seen suits where employers discriminate against them on the basis. Again, going back to something Mike said, it's treated a lot like alcohol, right? Alcohol is legal everywhere in the United States. If an employee wants to go home after work, go to happy hour, et cetera, we're not going to discipline them for that alone. So consider marijuana the same way. In Connecticut, we saw a suit again from an employee who was refused a job due to her valid use of medical marijuana. We do anticipate there'll be a lot more claims the more prevalent this becomes. At Jackson Lewis, we're very focused on preventative practice, right? So my goal here is to consult with our clients as these issues arise and make sure we come up with the best strategy to avoid these types of lawsuits. And a lot of the times these are easily avoidable claims. But yeah, that's what we're seeing. And going back to what I said before, it's typically when the employer just acts too quickly and doesn't really think through the issues before refusing to hire someone or terminating someone.
And if I can just add something, I think it's important to note here. Most of these cases, and Joe gave a few examples, we're talking about what I call single plaintiff cases. As a lot of you in the audience will say, I'll look to my insurance, I'll look to my insurance. I'm sure you've seen, rising deductibles over the last few years. It's very possible that your insurance policy is just not going to cover you when you have a single plaintiff, let's say a discrimination claim that evolves out of a marijuana use. So it really is important, I think, for people to be aware of that deductible and where a basket of claims, especially those single plaintiff claims, starts to move outside of insurance coverage.
Yeah, and I think having a legally vetted policy in place, as Joe and Michael have mentioned, that's going to help you, at least as regards defense, more than anything else when it comes to these claims. We've all seen, claims, meritorious or not, are being brought. But if you have a policy that's presented to the employees, they're aware of it, you're clear cut on it, and you've already vetted it through legal counsel, you're that much ahead of the game in terms of being able to respond to such allegations.
And if I could just ask Jonathan and Joe a question, Jonathan, what, if you can off the top of your head, what is the average deductible retention that you're seeing in your EPL space for your, middle market client? And then I would ask Joe what the average settlement value is for, let's say, a single plaintiff marijuana discrimination claim. I think that's important to note because that may reflect how much of this gets covered and how much of it doesn't.
Yeah, absolutely. And the way employment practice policies are put together, it's usually by employee count. So the more employees you have, the more premium you're going to pay, and probably the higher retention because of that risk factor. There are that many more people that could bring a claim against you. So, we've seen in the middle market space, true middle market, not small or not for profit, but true middle market, they can be $50,000 to about $250,000, I think, are the most common self-insured retentions that we see. So not an insignificant amount of money for any of these matters. Sometimes you can get them for about $25,000, but there's a pretty wide range depending on the size of your company.
And Joe, can I ask you just a fact pattern? I like to smoke every day after lunch. I go to the parking lot. My boss gets wind of the fact that I'm going to the parking lot and coming back and slouching at my desk. He follows me into the parking lot, and I sue him claiming discrimination. The firm discriminated against me because of my gender, race, whatever, and that's why they followed me to the parking lot. They didn't follow anyone else. What's a case like that worth typically?
Yeah, so I mean, assuming that they're able to prevail in whatever their underlying claim is, and we'll just assume here for the purpose of this hypothetical that they do, it's going to be completely dependent upon the jurisdiction and also on typically how much money they earn, right? So when you consider what the available damages are, there's economic damages, compensatory damages, and punitive damages. Punitive damages are so hard, so we won't even talk about them. But economic damages, that's the back pay, the amount of money they would have continued to earn at the employer but for the unlawful termination. Front pay, the amount of money they would have earned post the date of judgment but for the unlawful termination. And then the real numbers are emotional distress damages and attorney's fees. So emotional distress damages in New York, let's say in the Second Circuit, it could be anywhere from $25,000 to $125,000 for garden variety. That means the plaintiff just testifying that they experienced some sort of emotional distress. Then that number could go up if it's supported by medical documentation, et cetera. And then they're entitled to recovery of their attorney's fees, which if you take a case through trial, depending on where you are, you could end up paying the plaintiff's attorney $100,000 to $200,000. So to answer your question, I mean, it could end up being $300,000, $400,000, $500,000, $600,000 and up if the emotional distress is more or if it was a higher wage earner.
Okay.
And
So
I think
some good news that the insurance policy will come into play, but still there is a pretty heavy deductible retention amount that will be absorbed by the insureds.
And I think states like California, the settlement values could, increase astronomically, especially with the concept of nuclear verdicts. All right, so
And what insurers are doing too in California, sorry, more, what we've seen insurers do in some of those, what we'll call judicial hellhole jurisdictions like California, they'll have separate California retentions where they will be higher. Or high wage earner retentions, where people who make more money, there will be a higher retention applicable to that claim. While we certainly try to avoid those, it's something that the insurers have done to reduce their exposure. So just something to be mindful of if you have employees in those locations.
absolutely. All right, pay transparency. So Joe, this is for you. Pay transparency has been a key issue. Employers and employees traditionally have had policies where you can't talk about your salaries. But now with the enactment of the pay transparency laws in various states, employees are openly discussing their salaries, but also they're more vocal in terms of disparities. Can you talk about the various laws that you're seeing and some of the nuances?
Yeah, so the first one I'll start with is the National Labor Relations Act. That specifically says protecting concerted activity includes employees being able to speak candidly about their salaries. So any policies that prohibit that, generally speaking, are going to be a violation of that law. What we've seen more recently are these pay transparency laws, these are just regulations that require employers, generally speaking, to disclose information about employee compensation, either to the employees themselves or to the public. The specific requirements of these laws can vary depending on the jurisdiction, but they generally aim to promote fairness and reduce pay disparities based upon factors like gender, race, or ethnicity, right? So when you think about the public policy behind it, you're trying to close that pay disparity gap. The government wants employers to pay people for the job they're being hired to perform, not based upon what their last salary was or something else, right? So what these laws require is these employers to be more transparent with the salary ranges and benefits associated with the position. So what they're basically requiring is you have to provide applicants the salary range for a posted position at a specified point during the hiring process. You have to provide employees salary range upon request when changing jobs or upon hire, and that includes salary ranges in your job posting. So you need to be thoughtful as to, we're hiring someone to be an accountant at our firm, and we typically pay accountants entry level $50,000 to $60,000. That would be the appropriate range. The laws typically don't allow you to say minimum wage of $15 and up, or a maximum of $50,000 per year, right? You have to give it an actual range that you're looking to pay a person who's qualified to do that position.
Thank you. And in terms of Washington, Washington tends to be very employer adverse traditionally. So what about the Washington Equal Employment Act, Equal Pay and Opportunity Act?
Yeah, I mean, Washington's getting a lot of press right now because they have a lot of different class action suits related to this, where there's violations of the law, large pay gaps, and it's being focused on. But it's actually more systemic than just that. I mean, many states are looking to this. I think we're up to 17 or 18 different jurisdictions, with more on the way, that are focusing on this pay gap. And really, I mean, I think where it's aimed is pay equity, right? That's what's going on. So one of the big things we're doing here at Jackson Lewis on behalf of clients is doing a lot of different pay equity audits, doing a lot of different audits of job posting practices, and really determining for each job title what we're willing to pay. And that's how you avoid these class action suits, right? When you talk about class action as opposed to single plaintiff, now you have multiple people who may have tried to apply for a position using the same exact job posting, and you could end up with, instead of one plaintiff, you can end up with 30, 40, 50, hundreds of plaintiffs. So we're seeing that happen in Washington. It's happening other places too. So yeah, it's a big thing. It's on the government's to-do list to pay attention to. The DOJ and EEOC are all over it. So it's a big topic right now.
So Mike, in terms of the risk management aspect, what are some of the traps that lead to increased exposure, and how do you counsel your clients in reducing that risk?
You know, unfortunately, I think I cede this territory more to the HR folks. I don't get involved as much in the pay issues. So I defer that to the experts. But I think it is important for everyone to be aware of what you disclose to applicants, how you promote an opportunity, and failure to do so can expose you to risk.
And John, in terms of the EPL aspect, I know some of the cases will be asserted as discrimination case when they're filed, and therefore they trigger the usual EPL coverage. But what about coverage for the Equal Pay Act, which is essentially an amendment to the Fair Labor Standards Act?
Sure. So I'll answer that, and then we did have a question I want to throw back to Mike and Joe. Yeah, Equal Pay Act claims are covered under employment practices policies. So to the extent that you are facing any allegations or any claims of alleging violation of the Equal Pay Act, that certainly is a claim under the EPL policy, and one which we would recommend and assist you reporting under your EPL policy. the coverage is rather broad. It doesn't necessarily have to use that magic word of discrimination. Merely a violation of one of these statutes can trigger coverage. Going back to one of the questions we have in the queue, I want to pass along. It's a New York specific question, and they're asking, do they need to include pay transparency verbiage in a New York employer handbook?
So you should include that in there as it relates to lateral moves or promotions within the company. You wouldn't have to include anything about job postings because by the time a person receives the employee handbook, they're beyond that point. So yeah, I mean, it's a pretty simple policy, but it should address those items.
All right, it looks like we're doing pretty okay on time. So last issue we'd like to talk about is
I'm sorry, just a quick question for Joe. I mean, Joe, if you haven't updated your employee handbook in 2 years, is there a pretty good chance it's missing a few things?
Yeah, for sure. 2 years, especially in New York. Again, this is going to depend on where you are, but we recommend our clients look at their handbooks annually to see if there's any updates. It's one of those items that if you do it annually, each time you do it, it's a pretty light lift because not too much changes, but stuff does change. If you wait 5-10 years, now you're talking about a whole overhaul of a handbook, which requires more training and getting your people up to speed to actually comply with the policies in that handbook.
Okay, and we had one more question come in. What are the main risks associated with pay differences for the same job title in different locations? And have you guys run into that?
Yeah, so you have to be guided by legitimate business decisions for doing what you're doing, right? So a person in New York City likely will make more money than someone in Albuquerque, New Mexico. That's just the nature of it, even if it's the same exact job title. So as long as you're posting that same range in that same location, you'll be fine. In the posting, if you're just doing one generalized post, what I've seen employers do is they'll say, like, if you're in this area, this is the range. If you're in this area, this is the range. And that comes into play when it's a remote worker. So you can do something like that. And your defense, more often than not, in the employment context, is did you have legitimate, non-discriminatory, non-retaliatory business reasons for doing what you did? So if you can explain it with a straight face, right, like you're not lying, you could pass the red face test as to why you did what you did, and tie it back to these legitimate business reasons, then that's going to be a fine explanation. Where we've seen in New York, like the biggest issue we see is like the ranges. We'll pay you $25,000 to $125,000 for this job. It's just not a realistic range, and that's where a lot of the claims are coming in.
Thanks, Joe.
awesome. So we're kind of coming down to the last few minutes. So let's just go ahead and touch on our last topic, which is the Pregnant Workers Fairness Act. So Joe, this is for you. Traditionally, women have brought pregnancy-related claims under Title VII, under the Pregnancy Discrimination Act as an amendment to the Civil Rights Act, and also the ADA. Now we have the Pregnant Workers Fairness Act, which can be viewed as Pregnancy Act 2.2. Can you talk to us a little bit more about the act and the top 3 things that employers need to know in terms of their employees?
Yeah, so this is a new law, and it requires employers to provide reasonable accommodations to workers' known limitations related to pregnancy, childbirth, or related medical conditions, unless the accommodation will cause the employer an undue hardship. So it sounds very similar to the ADA type analysis that you all may be familiar with, but instead of disability, it's known limitations, right? So it's a much lower standard as far as what the employee's condition needs to be. Whereas under the ADA, when you think about it, the pregnancy needs to have a disability associated with it. A pregnancy in and of itself is not a disability. Now, being pregnant creates a known limitation, and that requires an accommodation. So the top 3 things to know. The PWFA only applies to accommodations. It's not a discrimination-based statute, so it just requires employers to accommodate employees with these known limitations. it also requires an interactive process, very similar to the ADA. It's not the employee makes a request for an accommodation and we just say we can't do that. The answer is no. It requires a dialogue, us going back and forth to figure out whether there's a reasonable accommodation that can be provided. And on the slide, we listed 4 accommodations that are almost always reasonable. I won't read them to you, but you can see them there. Just you can keep that for your reference. And then I guess the third biggest takeaway, and you kind of mentioned this in your question to me, the PWFA isn't the end of consideration. You still have to be mindful of Title VII, ADA, FMLA, Pump Act, any state or local laws that may apply to pregnant workers. So it's not just a simple pregnant worker, PWFA. It's pregnant worker, PWFA, and then some.
Thanks. Mike, do you have anything to add in terms of the risk management perspective?
I don't know. I mean, the only thing I'll say is, I do have the benefit of having, 1,000 wonderful lawyers to help me on these employment related matters. But for everyone else, it's a challenging minefield. How does a risk manager or the person in charge of being up to date on things, how do they know? How do they make sure that their company that they're going to be responsible for is taking care of all these trends and making sure that they're up to date? That's a challenge. Again, I benefit from having people like Joe working alongside me. But if I didn't and I worked for a commercial enterprise, I would be very concerned with all these topics. And again, each one of these topics 2 years ago, we would never have even heard of it before, right? It is, I think, a very fast moving landscape in the employment world that has gone way beyond just, discrimination, harassment, wage hour, and those things. And I think you have to be very mindful of that.
And we did have a question that came in regarding pregnant workers. The question is, if a merit increase takes place when an employee is on maternity leave, do they provide the increase on the effective date or the date when that worker returns to work?
That would depend on how you're paying the employee while they're out on leave. To the extent that they're still receiving their paycheck, it will be on the date of the merit increase. If they're on an unpaid leave of absence during that period of time, it would just resume at the point that they come back to work. There's no legal requirement for retroactive pay in that situation while an employee is on an unpaid leave, but you're certainly permitted to do so.
Great, thanks,
Right.
Joe.
So we're running out of time here, and I know we want to discuss the EEOC enforcement trends. Joe, if you can just talk about the top 3, any increases that we saw over the last couple of years, that'd be great.
Yeah, sure. So we saw the significant increase in vaccine-related charges, which during the height of COVID and when the COVID vaccine came out, there was an uptick in charges, typically disability charges and religious discrimination charges. And that's where every single day, almost every single hour of every single day, I was getting a letter from an employee of a client saying they have a sincerely held religious belief preventing them from getting the COVID-19 vaccination. So a large uptick in the EEOC charges we're seeing pertain to those types of things, the religious discrimination because of the vaccine, and then those with medical conditions that prevented them from getting the COVID vaccine. The total number of claims, just generally speaking, is up. It's becoming more and more litigious every single day. I think it's in part because of social media. There's a lot more transparency now. People are communicating with each other at higher and higher rates. It's become very easy to file complaints, especially with the EEOC or any, like the New York State Division of Human Rights. Like you could do that pro se. You check a few boxes, you write a few sentences, and anyone can basically do it. And now the obligation is on the employer to actually defend it. And sometimes they're meritorious claims, sometimes they're not. But we don't see any downturn at all in EEOC filings. We don't see any downturn right now in lawsuits. I think across the board in basically every single employment category, litigation is up. So my advice, what I work for my clients, what we do as a firm at Jackson Lewis, again, we preach preventative practice. A lot of these claims can be avoided, and Sometimes they can't be, right? And someone's going to file a complaint or someone going to sue you, but we can give you the absolute best defense. You want to make sure that the policies are right, that the file is padded the right way. This way, when the EEOC comes to investigate, we can say, here's our position statement, and here's every document that supports why we did what we did and why the plaintiff is wrong. And then at least you can nip these cases in the bud sooner rather than later.
Thank you for wrapping that up quickly. Someone say something? Mike? Okay. So yeah, thank you for wrapping that up for us. And unfortunately, we're at the end. I know we can talk about a lot of these topics for the next 2 or 3 hours, but we need to kind of wrap things up here. So John, I'm going to turn it over to you to kind of take us out.
Sure. So a couple of questions that came in, and I want to give Joe and Michael the opportunity to talk about themselves for a moment, as the folks on the line have asked about Jackson Lewis's capability and presence in states. So if you guys want to share your footprint and your staffing, I think people would find that helpful, as they want to, I think, be able to rely on, in essence, a one-stop shop if they're in multiple locations.
Yeah, I could start, Mike, if that's okay. So we are currently 1,000 attorneys strong, maybe slightly over 1,000 at this point. We're in 39 states across the country and Puerto Rico. We have international capabilities. We're part of LME Global, so we have partner firms around the world that we team up with to the extent that there's national operations. We're a large firm, but we're a boutique in that we only handle workplace law related issues with limited exceptions here and there. That means anything that has to do with an employer's relationship with their employees, whether it's on the employment side or the labor side. So when I say labor, collective bargaining, union trainings, negotiations, elections, those types of things. We have people that specialize in every single area, in every single jurisdiction. We are also on, I'm pretty sure, every single EPL panel that exists, which I think makes us more unique than other national labor and employment law firms. So we can be there day to day on the advice and counsel along the way. And then to the extent there's a claim that comes up that you submit to your EPL carrier, it's as simple as asking that carrier to assign Jackson Lewis to handle the claim. And you could have continuity of service there, and you could have an attorney that's familiar with the underlying facts and was involved in the process along the way. I don't know, Michael, if you would say anything you wanted to add.
Yeah, no, Joe, that's a great point. I mean, I've seen situations where, you have a law firm, they're doing all the preventative stuff, but they're not approved by insurance carrier panels, which means, the insured has to go to a different law firm, and there's a certain amount of hours of work that now get duplicated. We are on every carrier's panel. I think while we have 39 offices, we have people who are in every single state. And again, everything we do is labors. So yes, we are eager to help anyone to make sure that their policies and procedures are up to snuff and will at least mitigate your exposure to lawsuits.
Thanks, guys. And as mentioned, the firm has multiple resources, not only in terms of attorneys, but they can also give you guidance in connection with employee handbooks and other things that you need to have in place to protect yourselves. So we're pretty much out of time. I want to thank you all for joining us today. Hope this was informative and helpful to you. If you have any questions or would like additional information, please reach out. Thank you again to Michael and Joe for sharing their expertise and their experience on these topics. Moira and I really appreciate it. And to the extent that you have any questions regarding insurance, coverage, claim submissions, we here at NFP are always available to discuss anything with you. Even if you're not sure if it's a claim or not, please reach out to us. So pick up the phone, send an email, whatever the case may be. We're here for you. Thank you again. And I'm going to kick this back to Amber to close us out.
And Jonathan, just one last point I wanted to make. When Jackson Lewis does choose a broker for our own insurance, we do choose NFP, and we work with NFP on our own insurance.
Thank you, Michael. Appreciate that.
All right. Well, thank you to all of our speakers for sharing your valuable time and expertise with us today. To reiterate, today's presentation was recorded and the recording will be distributed in the coming days. In a moment, a survey will populate in a new window when you close out of Zoom. Please take a brief moment to complete the survey as it lets us know what topics are important to our listeners and helps make our education program as current and relevant as possible. That concludes our webinar for today. Thank you everyone for joining us and have a great day.